My name is Neethi Chacko, and I have been working in CSI College for Legal Studies, Karnakari, and I'm presently associated with Cochin Law Chambers, Kottayam. I'm a member of this group, and I have been assigned to take a class review on the topic Law of Torts and General Defenses in Law of Torts. So, before moving on to the general defenses, I would like to tell you all that a detailed and beautifully crafted set of notes on general defenses has been provided in the LMS platform. So you all can make use of those documents for your perusal. I will be taking a very short review regarding this particular topic. So moving on, what is a tort? So before moving on to general defenses, we should be knowing what a tort is. To simply put into words, tort is a civil wrong or an injury. So wherever there is a violation of a legal right which is applicable to the society in general, when such a legal right is being violated, then it constitutes a tort. Now, since the the violation of the legal right can be directed towards the general public, it can also be said to be right in rem. Now, when that is the first element of tort. Now, the second element involved in tort is that whenever there is a violation of legal right, it should be redressed through unliquidated damages. So the second element in law of tort is unliquidated damages. So when we talk about unliquidated damages, there will be a question as to what is the difference between liquidated damages and unliquidated damages. Liquidated damages are usually damages that can be predetermined, and it is usually such damages are usually used in law of contracts, where wherever there is a violation, a certain amount of damages can be fixed prior in a contract and later on can be claimed, whereas unliquidated damages are claimed for losses which are unforeseen. Now, the word tort is derived from the Latin term tortum, which means a twist or to do a wrongful act. We all know that
Good evening, Nidhi. Your slide is not moving.
Is it not moving? Now is it moving?
Actually, it is not moving. I don't know. Is it correct?
Yes, it is okay now.
Okay, thank you. Yeah, now it's okay.
Okay. So the law of tort is not a codified set of laws, as we have derived this particular law from the English common law. So law of torts is actually unwritten, or it is not codified. In law of tort, the burden of proof always lies on the plaintiff to state that there exists a violation of a legal right, and the remedy has to be sought for such a violation. Now, there are three main features. Like I mentioned earlier, the three main features involved in a tort is that there should be a legal right, there should be a wrongful act through which the legal right should have been violated, and the third feature is that for the violation caused, damages should be claimed in the form of unliquidated damages. So these are the three main features of tort. Now, however, in certain cases, the defendants can save themselves or absolve themselves from the liabilities from the act of violating a particular legal right. Now, these particular exceptions are known as general defenses. Now, we move on to general defenses one by one. The first general defense is volunty non fit injuria. So it is basically a Latin maxim, and it means that whenever a person is willing to suffer or expressly or impliedly gives consent for suffering harm or injury caused by the actions of a defendant, then that person who has attained the injury or damage cannot claim against such a defendant or such an act. So this is volunty non fit injuria, and this is the first defense in law of torts. Now the defendant can in turn use the defense of volunty non fit injuria to absolve himself from the liability which may arise out of an infringement of a legal right. So for every defense following, I'll be explaining one or at the maximum two case laws. The rest of it is actually given in detail in the notes provided. So moving on to the first case law under volunty non-fit injuria. The first one is Illot versus Wikes. It was in 1820. So in this particular case, a trespasser to a land got injured due to spring guns that were present in the defendant's land. So in this particular case, the defendant had installed spring guns to avoid intruders or wild animals, basically for avoiding trespassers and wild animals. And here the plaintiff was very well knowing about the presence of spring guns in the land. So with the knowledge of the presence of spring guns, the plaintiff entered the land of the defendant. So the plaintiff was actually undertaking a risk of entering the defendant's land, and thus he sustained injuries from one of the spring guns. Now, in an action brought by the plaintiff against the defendant, the court held that the defendant was not liable in such a case because the plaintiff was well aware of the presence of the spring guns. So this is an example for the plaintiff giving his consent. Another case is that of Hall versus Brooklands Auto Racing Club. So this particular case also explains another attribute of volunty non-fit injury, that is the consent must be free. So nobody should be forcing the plaintiff to express his consent, but the consent must be freely given by the plaintiff. So in this particular case, the plaintiff had occupied the front row of a particular gallery where a car race was going on. And while the race was on, two cars collided, and one of the cars toppled onto the gallery, and a few of the spectators were injured. And these spectators included the plaintiff as well. Later on, the spectators brought an action against the defendant for claiming damages for the injury sustained by him. But again, in this particular case, the court held that the plaintiff had willfully taken the risk of occupying the front row of the gallery when he very well knew that there was a chance of an accident. So the defendant was again not held liable, and the defense of volunty non-fit injuria served good. Now, the next attribute of volunty non-fit injuria is that the mere knowledge of a risk involved in a particular act does not imply consent. So to explain this particular point, there is this case of Smith versus Baker, where the plaintiff was employed in a rock cutting factory. And while the stone cutting was going on, there were conveyance of stones happening above his head, and one stone fell over the plaintiff's head, and he got injured, or he sustained injuries from the stone that was fallen from top. Now, although in this case, the court held that although the plaintiff had the knowledge of stones that were being carried from one end to the other over his head, the mere knowledge did not amount to the consent. The mere knowledge did not amount to consent, and the defendants were held liable. Now, another attribute that is necessary for voluntary not-fit injuria is that the act must be lawful. The act to which the plaintiff is consenting must be lawful. So, in this particular case, Lane versus Holloway, it was held that although each of the parties to an ordinary fight voluntarily accept the risk of incidental injuries, the plaintiff had not consented to risk of a savage blow out of all proportion to occasion. So in this particular case, what happened was there was a fight going on between two people, and the fight blew up into a proportion which was out of control. So in that particular instance, the plaintiff had not consented to a heavy blow which he had sustained from the defendant's side. Okay. Now there are so many more cases that can be taken as support for the defense of voluntary non-fit injuria. A few of them have been mentioned here, and a lot of them has been mentioned in the notes given on the LMS platform. Now, another point to be noted is that voluntary non-fit injury is not applicable in rescue cases. That is an exception to voluntary non-fit injuria. So this particular case can be, this particular instance can be explained through the case of Haynes versus Harwood, where a boy threw stone on a stone on an unattended horse, and the horse started making chaos in the public, and people started panicking and running around. So in order to save these people from the horses, a constable stepped in, and he sustained injury while bringing the horse at bay. So in this particular case, voluntary non-fit injuria cannot be taken as a defense. The second general defense that can be brought in law of torts is the plaintiff being the wrongdoer. So there is a maxim known as ex turpi causa non oritur actio, which says that from an immoral cause, no action arises. This means that when the cause of action itself is not in itself legal, then an action cannot be arising out of such an act. So this can be explained through the case law Pitts versus Hunt, which happened in 1991, where two riders, the rider was 18 years of age, and the person riding on the back of the bike was 16 years of age. Both of them were in an intoxicated state, and the pillion rider, who was 16 years old, encouraged the rider to drive fast in the drunken condition. So the rider drove fast, and it led to an accident, and the rider succumbed to the accident. But the pillion rider suffered serious injuries, and he later on filed a suit for claimant compensation from the rider's relatives. And this particular case, when it came to the court rejected his claim, saying that he himself was in an intoxicated state, and he himself encouraged the rider to ride fast. So he was not himself doing a right thing. So he himself was a wrongdoer. So there was no compensation that could be claimed from the rider's family. Then comes another general defense, which is inevitable accidents. So accidents, we know it is an unexpected injury. And a lot of accidents take place now and then. But if an accident could have been stopped or avoided, if an accident could not have been stopped or avoided in spite of taking all possible due care and precautions from the part of the defendant, then we can call it an inevitable accident. That is, every precautions were taken care of, but still the accident occurred. In such a case, we can take the defense of inevitable accident. So this particular point serves as a good defense, as the defendant could show that the injury could not be stopped even after taking all the precautions. And there was no intention to harm the plaintiff. So Starley versus Powell, 1891 is the best example to explain this particular case, this particular general defense, where the defendant and the plaintiff were on a pheasant shooting. Pheasant shooting is an activity that is carried out as a leisure, where pheasant birds are shot for pleasure. So the defendant and the plaintiff went on a pheasant shooting, and the defendant fired at a pheasant, but the bullet, after getting reflected by an oak tree, it hit the plaintiff. Here, the defendant did not have any intention to harm the plaintiff, and he took all the precautions, but still, the bullet hit the oak tree and it came and hit the plaintiff, and the plaintiff in turn suffered serious injuries. The incident was considered as an inevitable accident, and the defendant was not held liable in this case. Again, another case that can be stated is Assam State Corporation Federation Limited versus Srimati Anupha Sinha. This is a case that happened in 2015, where the plaintiffs, there was a premise which was let out to the defendant. That is the tenant. The tenant requested the landlord, who is the plaintiff, to repair some electrical wirings in a particular portion of the building which was given out to the plaintiff. The wiring was defective, but the landlord did not take care of this particular aspect, and the landlord actually failed to repair the wiring. And in turn, after due course of time, there was a short circuit and an accidental fire spread in the house. Now, this was an inevitable accident that happened because the defendant had taken all the possible precautions, and the defendant had informed the plaintiff about the defective wiring. So, in this case, it was held that there was no negligence on part of the tenant's side, and in an action by the landlord to claim compensation from the tenants, it was held that it was a case of inevitable accident. Now, these are a few case laws that come under inevitable accidents. I've just written the case laws and the power points that you all could understand. Now, the next general defense is act of God. So, act of God serves as a very good defense under the law of torts. It is also recognized as a valid defense in the rule of strict liability. Now, this strict liability was originated from the case of Ryland versus Fletcher, and act of God was also considered as a defense. Now, the defense of act of God and inevitable accident might look the same, but they are different actually. In an inevitable accident, it can be because of certain technical reasons or man-made reasons. But act of God happens due to natural forces. Natural forces play the role of creating inevitable accidents and damages. So damages that happen due to heavy rainfalls, storms, tides, landslides, etc., everything can come under act of God. Now, there are two elements that come under act of God. That is, the first element is that it should be a work of natural forces, and the act must have happened extraordinarily. So, extraordinary occurrence should be there. So, these are the two elements of act of God. So, this can be best explained through the famous case of Nichols versus Marshland, where the defendant diverted a natural stream on his land to create ornamental lakes. And later on, there was heavy rainfall happening, and it caused the artificial lake to flood up and the waterways to be flooded, and it in turn damaged the adjoining land of another person. And the court held that the defendants were not liable as the same was due to the act of God. So, in this particular act, the defendants could not foresee such an exceptionally heavy rainfall coming through. Then the next general defense is the private defense. So the law has given permission to protect one's life and property, and for that, it has allowed the use of reasonable force to protect himself and his property. So application of reasonable force to protect oneself can be said to be a good defense in law of torts. So the conditions to apply private defense is one, the use of force is or should be justifiable, and it should be only for the purpose of self-defense. The second point is that there should be an imminent threat to a person's life or a property. Imminent means a very immediate threat to a person's life or property. So there are two cases in under private defense. That is, one is Bird versus Holbrook in 1825. In this case, the defendant had fixed up spring guns on his garden without displaying a notice regarding the same. There was no notice set up outside his property, but he had set up spring guns in his garden. And there was a trespasser who suffered injuries due to its automatic discharge. So when a person passed by his land, the spring gun automatically discharged, and it injured the plaintiff. In this particular case, the court held that this act of the defendant is not justifiable, and the plaintiff is entitled to get compensation for the injuries suffered by him, because there was no information regarding the spring guns anywhere mentioned in or near the property. So the force applied by the defendant was not actually justifiable. The second case is Collins versus Renison, 1972, where the plaintiff went up a ladder for nailing a board in the defendant's garden. And the defendant, thinking the person to be a burglar, threw him off, actually shook his ladder and threw him off the ladder. And the the plaintiff, sustained injuries. And later on, when a case was brought against the defendant, he pleaded that he gently shaked, or he gently pushed the plaintiff down the ladder and nothing else. He didn't do anything else. But it was held that the force used was not justifiable. Again, in this case, it was held that the force used was not justifiable. Then comes mistake. So I forgot to write it on top. So the next general defense is mistake. Mistakes are of two types: mistake of law and mistake of fact. And here comes the next maxim, known as ignorantia facti exquisite and ignorantia juris non exquisite. Here, in the law of torts, both these conditions cannot be excusable. So no defense is available to the defendant. Now, when a defendant acts under a mistaken belief in some situation, then he may use the defense of mistake to avoid his liability under the law of torts. So to explain this particular case situation, the case of Morrison versus Ritchie and Company can be taken, where a publishing house mistakenly published that a lady had given birth to twins, where the lady had just got married 2 months ago. Okay, and in this case, mistake of fact could not be pleaded. Then the next general defense is necessity. So if an act causing damage is done under a necessity to prevent a greater damage or a greater evil or a greater wrong, it is not actionable in tort. So the case that can be explained is Carter versus Thomas, 1935, where the defendant had to enter the plaintiff's premise in good faith to extinguish a fire. And it was proven that he was working under necessity to prevent a greater evil. And therefore, the person was not held liable for the tort of trespass. Also, in Lay versus Gladson, 1909, a person who was under a hunger strike was forcibly fed because she had to survive, and there was a necessity of her survival. Then the last general defense is the statutory authority. So when the legislature or any lawmaking body of a land authorizes or directs something to be done, then the damage resulting from such an act will not be actionable. And when an act is done under a statutory authority or duty, it is a complete defense in itself. So any act brought about by a legislature through a statute is or can be considered to be a defense, a complete defense in itself. So to explain this case, we can take Hammersmith Rail Company versus Brand, where a railway line was constructed near the plaintiff's land. And due to the constant loud noises and vibrations produced from the running of trains, the value of the plaintiff's property started depreciating a lot. And the plaintiff brought a case against the railway company, but then the court held that nothing can be done or claimed as damages because the railway lines were set up as per the statutory provisions. So these are the general defenses that come under the law of torts. A lot more cases are there to back these general defenses, which are provided in the LMS platform. Now, there are 2 or 3 questions that I've taken from previous question papers. The first one is, consider the following set of legal propositions. A person can claim damages for all wrongs he has suffered. A person can claim damages for wrongs only if they are caused intentionally. A person can claim damages for a wrong if it is caused by infringement of the legal right. The fourth option is a person can claim damages even if he has suffered no loss. The answer is 3 and 4. The next question is, which of the following defenses to strict liability is based on the maxim volunty non fit injuria? So here we have to see, it is asked the defense of strict liability which is based on the maxim volunty non fit injuria. So volunty non fit injuria is usually used where the consent of plaintiff is taken. Now the third question, moving on to the third question, this is to match the list on the right side with the left side with the right side. So for this, the correct answer is given, that is 1, 4, 3, 2. So here I come to the end of the class review, and this is the bibliography. These are the materials that I have perused to make my class review presentation. Thank you, one and all.
The president has some powers as per the constitution to declare some issue as a federal issue, and then they can take over. So you have the federal investigation team